forever. And one of them is that only government can violate the First Amendment. Corporations can't violate the First Amendment. Labor unions can't violate the First Amendment. Churches can't violate the First Amendment. Only government can violate the First Amendment. And that's because our Constitution is a series of constraints on government and on government alone, restricting what the government can do, not what the people can do, or not what other institutions in society can do. Take Twitter as an example. You remember back during the London Olympics this summer, Twitter canceled the account of a reporter who had tweeted something critical of NBC and NBC's time delay in reporting on what was happening in the Olympics. And the reporter included in his tweet the personal email address of the NBC executive who was responsible for the coverage. Twitter canceled his account. Did that infringe his freedom of speech? Indeed it did. Sure did. He can't tweet anymore. They rescinded it within a week because of the outcry, but it certainly infringes free speech. Does it violate the First Amendment for Twitter to do that? No way, because Twitter is not the government. Same thing with Facebook. This may not be up to the moment, but this is an excerpt from Facebook's terms of use, in which all of you have agreed to, which prohibits you from saying anything hateful or contains nudity or graphic or gratuitous. What's gratuitous? Violence. And prohibits you from intimidating or harassing any user, and prohibits you from doing anything that's misleading or malicious or discriminatory. Well, does that infringe your free speech rights? It certainly does. Does it violate the First Amendment? All together now say, no! Facebook is not the government, at least not yet. No violation of the First Amendment because Facebook is not the government. I suppose it's useful to consider some of the reasons, or the reasons commonly given, for why we have constitutional protection for free speech. Over the centuries, various scholars, judges, philosophers have opined on why we need to have free speech. And you can distill most of their writings down to 3.5 items. One is, we need free speech in order to find the truth. You don't find the truth by suppressing false points of view, or points of view that you disagree with, or bad ideas. You find the truth in an open, robust marketplace of ideas, where everything can be considered, and where, it is thought, good ideas will emerge and chase out bad ideas. So you have the marketplace of ideas concept as furthering the interest in finding the truth about any subject, about what our government is doing, about who's the best artist, about who's the best mathematician, thinker, and so on. So the interest in finding truth favors freedom of speech. And then there's a second reason for promoting freedom of speech in the press, and that is that it's essential to our system of self-government, that we have to permit all points of view, including criticism of our existing governors, the people in charge temporarily, so that when the next election comes, we the people can intelligently vote and change our government if we wish. So that you need freedom of speech and press in order to have a functioning democracy. And then a third interest that suggests that we need free speech is one of self-fulfillment, of individual autonomy, the ability that each of us has to express ourselves, whether it's in painting or poetry or politics or whatever it is, that we are free from the government deciding what's orthodox and permitted here. We can decide for ourselves and say so. We're free to think what we wish and say what we think. And that interest in self-fulfillment or individual autonomy is a reason why free speech needs to be protected. And then the half reason is really a negative justification for allowing free speech, which is, what's the alternative here? The government decides what can be said and what can't be. And we protect free speech because, to a large extent, we don't trust the government to make those kinds of decisions. We don't trust the government to be able to sort out accurately, fairly, what is worthy speech from unworthy speech. So those are the traditional reasons. And I put in the reader an excerpt from a wonderful First Amendment text that put some flesh on those bones. You'll notice, as we consider the various free speech issues and the Supreme Court's resolution of them, that the court is not always consistent on which of these interests in free speech it is promoting by its decision. Sometimes they will emphasize the marketplace of ideas. Sometimes they'll address the interest in promoting democracy. But then you've got nude dancing or sexual expression in some way. That doesn't really promote democracy, and it's not essential to the marketplace of ideas, but it happens to resonate with the interest in self-fulfillment. And so the court doesn't always consistently treat these interests either, but these are the interests that have been identified as animating the court in protecting free speech. So the other basic principle to take away today is the one that we talked about before. The First Amendment means what the Supreme Court says it means, and it says so when it is exercising its power of what is called judicial review. We'll come back to this when we consider features of the American legal system that affect freedom of speech in the press and so on. But the power of judicial review is the power that courts have, all courts, not just the U.S. Supreme Court, that all courts have to find an act of the legislature or of the Congress or of the president or of the executive branch or of the governor or of the mayor unconstitutional and unenforceable. It's an extraordinary power that American courts have that few, if any, courts in other countries have. I mean, in Belarus or in China, you're not going to find the courts empowered to say that something that the executive branch has done is unconstitutional and can't be enforced, or that an act of parliament someplace is unconstitutional and can't be enforced. But under Article 3 of our Constitution, we have a Supreme Court authorized to decide cases, quote, arising under the Constitution and laws. That's the first time in history that a country established such a national court to decide cases like this, and it's an unusual feature of our Constitution. I'm sure most of you are familiar with at least the name Marbury versus Madison. It was a case decided by the United States Supreme Court in 1803. That was the first time that the court invalidated an act of Congress, finding it unconstitutional, in an opinion by Chief Justice John Marshall. It's a landmark of American law that established the power of the court to say what the law is, to say what the Constitution means, and to say that the Congress or the executive branch has violated the Constitution by something they have enacted or done. This power of judicial review, as I say, is breathtaking and not very democratic when you think about it. Here's this little band of judges, not elected democratically, who get to say that the people's branch, Congress, has screwed up and passed a law that's unconstitutional. It's amazing. The power of judicial review was exercised by the courts sparingly in the 19th century. The next case after Marbury versus Madison was 54 years later in the Dred Scott decision that, as I'm sure you're aware, led to that invalidated the Missouri Compromise on slavery and led to the Civil War. There were very few cases other than those two in the 19th century. Now, exercise of the power to invalidate congressional statutes is much more common. In history, about 150 federal laws have been struck down by the court. Total. Two of them last June. On the last day of the Supreme Court's term in June, the court decided two cases, one of which was the Obamacare decision, the health care decision, and while the mandate part of the law was upheld as a tax, the court invalidated the provisions requiring the states to expand their Medicaid programs as a violation of the Constitution throughout that important provision, leaving it up to the states whether they wish to accept federal money to expand their Medicaid coverage. And on the same day, overshadowed by the health care decision, was a case that found the Stolen Valor Act unconstitutional. It's a wonderful case, one that we'll pay close attention to. A man by the name of Javier Alvarez lied about having received the Congressional Medal of Honor, one of the highest military honors that Congress can bestow. Said he had won the Medal of Honor, which was an outright lie. And his lie violated the Stolen Valor Act that Congress had passed. And he was sentenced to prison. An appeal, case went to the Supreme Court, and last June 28th, the court decided that the law was unconstitutional. So does that mean we have a constitutional right to lie? I wouldn't look at it that way. I wouldn't frame it that way. What we have is the court saying that government's power over what we as individuals say about ourselves is limited. Anyway, we'll take a close look at that case. But there were two instances of the court exercising judicial review just last year. Now let's look at the current, you guys are a little late or a little early. Now let's look at the current Supreme Court. I want to spend some time on who's who here. We've identified who they are. We have 9 justices of the court, and the number has been set at 9 since 1869. Before that, they had fewer. Roosevelt tried to pack the court with more. We've settled on 9, seemingly, for the future. How do you get to be a Supreme Court justice? You're not elected. How do you get to be a Supreme Court justice? Yeah. Right. Both other branches of government are involved in the process. The Supreme Court judge, in fact, all federal judges are appointed by the President of the United States. That's not enough. They have to go before Congress and be subjected to hearings about their competence, their history, their views, and so on, before the Senate, and then the Senate of the United States votes either to confirm or not confirm the President's appointees. Each of the justices of the court and all federal judges have life tenure. They are appointed for life, not 4 years, not the term of the President's office, not 10 years or some other figure, but they're in there for life. And some of them have served a very long time and will in fact serve life terms. They'll serve their entire life in the court, die in office, maybe. That has some consequences, life tenure, that we need to talk about in more detail than we've got time for today, so that's where we'll pick up on Thursday.